Good evening, everyone, and thank you for joining us for this estate and will planning webinar. We are delighted to have you tonight. We're going to get started with our presentations in just a minute, but first I wanted to let everyone know that tonight's webinar will be recorded, and we will be sending all of the attendees a link to view the recording after the event is over. My name is Meg, and I will be your host and moderator for the night. And before we get started, I wanted to acknowledge that the University of Waterloo, much of our work takes place on the traditional territory of the neutral Anishinaabe and Haudenosaunee peoples. Our main campus is situated on the Haldeman Tract, the land promised to the Six Nations that includes 6 miles on each side of the Grand River. Our active work towards reconciliation takes place across our campuses through research, learning, teaching, and community building, and is coordinated within our Office of Indigenous Relations. So tonight, you are welcome to submit questions during the presentations and afterwards. We will be answering those questions aloud during moderated portion after the presentations are over. You may need to hover over your screen, but you should see when you do that a black bar that comes up that looks just like the one pictured here. In order to submit a question, please use the Q&A button on the right that we have highlighted in red there. So you can submit any of those questions, and we're going to get through as many of them as possible. If you have any questions afterwards, please do feel free to email plannedgiving@uwaterloo.ca. We'd be happy to reply to any questions that you have and that you send there. I also want to let you all know that closed captioning is available. If you would like to use this feature, you can see that there's a show captions option that is also highlighted in red there in that same toolbar. This webinar is provided as general information. The presentation is based on tax and estate laws in Ontario, Canada, and is subject to change based on individual jurisdictions. We do encourage you to seek independent legal and financial advice outside of this webinar if you have any other questions or want to put any of the things you learn into practice. And with that, I would like to present and welcome our panelists. So tonight we are joined by Keith Masterman, a lawyer and lecturer, Elizabeth Duranyik, an investment advisor and certified financial planner with RBC Dominion Securities, and Karen Wilkinson, the president of Karen Wilkinson Professional Corporation. Thank you all so much for joining us, and we're going to start, like I said, with some brief presentations from each of our panelists, and we'll begin with Keith. Keith, take it away.
Thanks very much. I guess I'll start with one general comment that has nothing to do with the webinar. I'm really thrilled that I'm wearing a jacket that's not the same jacket in the picture you just showed. I'm always afraid that people are going to think I only own one jacket whenever I see a picture. So that dodged a bullet there. What I wanted to talk to you guys about for a few minutes was the importance of having an estate plan. And I really am basing my conversation with you tonight on that statistic you see in bold letters there. 56% of adult Canadians do not have a will. So look to your right, look to your left. 1 out of 2 of us doesn't have a will, or a little more than 1 out of 2. Of the Canadians who have a will, and this is a statistic that really blew my mind, 30% state their will is out of date. In fact, about 30% of people who had a will said that they wrote their will when their oldest child was born, and away it went into a cupboard, never to be looked at again. And that was me. And I've been in the industry for 30 some odd years, 37, 38 years. And that was me. And so I'm going to use myself as a bad example of why you shouldn't do that. And why, if you have an outdated estate plan, you should take it out of the cupboard, dust it off, and read through it. And I guess a lot of it is the difference in my family, using myself as a bad example. So 38, 39 years ago, when Chris and I wrote our first wills, we didn't have an awful lot. We were a struggling young couple, as many couples are, and we were spending our money on foolish things. You know, Chris would get paid, that's my wife, 1 week, and we'd use the money on the mortgage. And the next week I'd get paid and we'd use it on food and hydro. There wasn't a heck of a lot at the end of the day. So there wasn't a lot we could do with our wills except make provision for any children that came along. Well, we're doing a little more, we're doing more comfortably now, and the children are adults. So one thing we can do with our will is we can hand down our values. You know, as a baby boomer, I look at the next generation and the generation after that, and I see totally different values. And one thing I want to do in my will is to hand down my values to my children. And I'm doing that now by using charitable gifts to charities like University of Waterloo that mean a lot to me. Just to say, you're important, but so is my community, and so is a whole bunch of causes that are important to me. I think it's Elizabeth, Karen will later tell us a lot about the income tax consequences of having charitable gifts in your will. I'm just going to leave it at that. Another thing that's changed over the last 30 some odd years is I'm now a grandfather 3 times over. And of course, my will 30 some odd years ago said that if one of my children predeceased me, their share should go to their children if they left any. But I didn't know the boys. I didn't know my grandsons, and now I do. And so there might be things around the house I want to leave to them, just for sentimental reasons. Or I might want to help out with their education or something else. But of course, my will is completely silent on that because I didn't know the boys 30 some odd years ago. Another thing that's changed in my life is I now have a daughter-in-law. And of course, my will was completely silent on her when we first wrote our will. Jack was just a baby. That's my son. But today, I know this woman, but I also know that there's a really good chance she's not going to be my daughter-in-law when I die. I'm old enough to have lived through the year when the divorce rate went up by 200% in 1 year, and the next year when it went up by 200% again. And I know that today the divorce rate's about 48%, so about half of marriages. So this woman who's tremendously important to me and a huge part of my family, I realize might not be part of my family when I die. And that doesn't mean I want to disinherit her. It might mean that I want to leave her something despite what happens with her marriage. But my will is silent on that because it's out of date and doesn't reflect my family. And I think one of the biggest changes that's happened to me, in fact, I know it's one of the biggest changes, is I now have a daughter. And, you know, suppose for a minute my daughter had been born with a disability. Suddenly, I have an issue because my will doesn't set out all the important things necessary to make sure she gets ODSP benefits, that's Ontario Disability Benefits, or make sure that she receives her money in a tax-efficient way that doesn't affect her standard of living. So all in all, when you look at my family today and what we were like 30 some odd years ago, I might as well use my old will to lie in a birdcage with, because it's completely useless to my life and doesn't reflect my family values. And any will you write should reflect your family values. The other thing I have there is that it doesn't meet up with tax changes and Canadian legal changes that have happened in the last 30 some odd years. You know, last year, Ontario went through the greatest number of changes in the estate planning field ever. Legislation was passed that changed so many things. It changed things like the effect of marriage on a will. It changed things like an ex-wife or ex-husband's rights under a will. It also changed things like, well, it didn't change things, but a couple of years earlier, legislation changed the definition of child. So who are potentially my children today is completely different than who children would have been 38 years ago when I wrote my will. So my will's dangerous because it doesn't reflect my family, and it's dangerous because it doesn't take advantage of all the new laws or reflect all the new laws. But that's not what I'm here to tell you about. Megan, why don't we change the sheet? Thanks. Oh, no, you didn't do it. Now, thanks. What I wanted to talk to you about was not having any will. So if you're one of the 56% of Canadians who don't have a will, what happens to your estate? In Ontario, every jurisdiction has a different system of distribution if you don't have a will. Some jurisdictions recognize common law spouses, some don't. Ontario doesn't. So if you have common law spouse and you die intestate, your spouse will receive nothing. If you're like me and you're married with a couple of children, I have 2 children, your spouse in Ontario will receive the first $350,000 of your estate. Then the remainder of your estate will be divided. Your spouse will get 1/3 of the remainder and 2/3 will go to your children. And that might be exactly what you want. It's not what I want. Chris and I have worked like dogs for the last 37, 38 years to look after ourselves first. And so I want to make sure the funds are available to her, but that's not going to happen in an intestacy situation. Intestacy simply means without a will. But I'm going to tell you a story called Reed Peters, and it's an Alberta decision of a couple of years ago. And I think it really reflects the importance of having a will. And Reed Peters involved a happy couple called Eileen and Lester Peters. They'd been married for about 46 years. And if you live beside them, you think there's a great couple with 5 adult children. You'd be wrong. What you really lived beside was a great couple where Mr. Peters had 5 children and Mrs. Peters had 1 child. Because Lester Peters had been married prior to his marriage to Eileen, and he and his first wife had 4 children. When the youngest of those children was a few months old, Mr. Peters' first wife passed away, and he was raising the 4 girls on his own. He met Eileen, he married her, and they had that 5th child, their son. So they had 4 daughters and a boy. The girls called her mom. She did all the things mothers do. She kissed knees, she bandaged things, she drove them here, there, and everywhere, all the things mothers should do. Mr. Peters died in around 2013, and when he died, he left his entire estate to his children. He left nothing to Eileen. And I don't think he was trying to be mean to Eileen. I think they had a whole bunch of registered accounts that were passed to her by right of survivorship, because registered accounts with a named beneficiary pass outside the will. And I think they had joint accounts, and a joint account, if properly done, will pass outside the will, pass to the surviving joint tenant. The problem is Mr. Peters, Lester Peters, had been a small business owner, and the business he ran went bankrupt about 3 years before he died. And all those joint accounts were securing debts of the corporation, so they all went into bankruptcy. Those registered accounts, Mr. Peters and Mrs. Peters, Eileen and Lester, began to live very liberally off of them because that's all they had. The bottom line is, Eileen Peters, after her husband died, didn't have enough to live off of. But the kids were good kids. And they got together, all 5 of them, and they said, I think what we should do is gift every single thing we got from Dad to Mom. That's what he would want. It'd be humiliating for Mom to have to ask us for money every time she wanted to buy groceries or go on a trip. Let's just give her that money. That's bad estate planning. Because you see, the night before you die, you're deemed to have sold everything you own at fair market value. And any registered accounts, 100% of them is added to income in the year you die for tax purposes. On any non-registered accounts or non-registered assets, the capital gain is calculated, and that capital gain is added to income in the year you die. So in the year you die, you're going to have this massive income inclusion for tax purposes. And remember, the highest marginal tax rate in Ontario is 53.53%. So that's going to be a big tax bill for your family. But if you leave your money to your spouse or into a spousal trust, then that tax implication does not happen right away. It only happens when your spouse actually distributes the asset or deals with the asset, or when they pass away. So if Lester Peters had left his money directly to Eileen, there'd be a lot more money for Eileen and a lot less money for Revenue Canada. But that's not what he did. He left it to the children, so CRA got their hands on it, and then it went to Eileen. Eileen lived off that money for the next 4 or 5 years, at which time she died. After she died, the 5 Peters children got together. And the girls said to their brother, I guess we divide by 5. There's 5 of us. Remember, this had been their money. And the son said, I guess we divide by 1. You guys aren't children, you're stepchildren. And there's not a piece of legislation in this country that recognizes the rights of stepchildren. So therefore, I get everything, you get nothing. They sued, and they lost. The judge who heard the case said, this is immoral, this is awful, this is disgusting. How could you treat your sisters this way? But this is the law. And if you don't like the law, then write a will. Write it now, because I'm not going to write one for you after you die. And so when I think of the Peters story, I just think of the importance of having a will. If Eileen Peters was sitting with you tonight, watching this webinar, and you said to her, how many children do you have? She'd hold up 5 fingers because she thought of those girls as her daughters. But because she didn't write a will, her reasonable expectations were destroyed. And I'll leave you with this thought. I've always told people over the last 38 years or so of being an estate planning lawyer that I have one job and one job only, and that is to make sure your family can still have dinner together after you pass away. When they're grieving in a very unique way and when they're upset, it's still important that they can get together as a family. And the best way of doing that is leaving a good estate plan that sets out what everyone should and should not have. And with that, Megan, I'm going to turn it back to you.
Thanks so much, Keith. That's great advice at the end, and in theory, very simple to follow. All right, so thank you, Keith. We're going to move on to our next speaker for the night. Elizabeth, take it away.
I wanted to thank Megan and the University of Waterloo for having the opportunity to share some of our insights tonight. I think this is a wonderful presentation and very timely as well for Will's month in November. I wanted to share a little story with you about something fun that's happening in our house. We're trying a whole ton of new recipes. And one of the things is baking, and we're trying to make all these wonderful cakes and things, and you get this recipe and you find it online, and it tells you the ingredients and it tells you the steps, and you do what it says, and then it doesn't really turn out the way you think it will. It's not as fluffy, it's not as light, it's not as moist, and then you go back into that recipe and you see there's these tiny little videos with a chef online who's perfected the recipe. And they start telling you things like, make sure the oven's on convection bake instead of regular bake, or take your eggs out and put them on the counter so they're not cold. Or you should be taking the baking soda and adding the warm water before adding it into your batter. So all these little tiny details that the chef has perfected to make this wonderful cake that you just kind of think, you know what, I'm just going to follow the instructions and it's pretty easy. It's not as simple as you thought. It's the same thing with the financial plan. It's not a giant calculator. Some of my clients think that you just plug the numbers in and it's a giant calculator. There's a lot of different attributes inside of a financial plan, and all those little tiny details are important. My clients often find that will take a lot of time to try and understand their family and understand the different nuances. There is lots of different situations with divorce. Myself, I'm part of a blended family. I have two wonderful stepsons. We've got education to plan for 4 children currently right now. There's a lot of different nuances when we're looking at a financial plan to take into account. So one of those things that often gets overlooked is charitable giving as well. And there's a lot of neat little opportunities for charitable giving, not just while you're living, but also through your will. And working with the financial planner, you can take you through all those different opportunities, look for those blind spots, and help you with each one of those details. One of the other people that you may be working with would be, of course, your lawyer to create your wills, to create those powers of attorney, an accountant to make sure that you're completing your taxes efficiently, minimizing your taxes, potentially looking at corporate tax situations, insurance specialist to make sure that you're taking care of your family in the case of an illness or a disability, the charitable giving donation coordinators, and of course, your executor, which Megan brings us to our next slide. An executor is someone very, very important in your overall financial plan and should know as much detail as your financial planner will know. I have a little story to tell you about one of my clients. Came into the office and sadly her husband wasn't doing well. And she wanted to make sure that her estate was in line. And we talked about the fact that her will originally had her 3 daughters as the primary executors. And I knew that one of her daughters was in Ontario and the other 2 were out of province. The one that was in Ontario had a professional career and she was quite busy in her career. And I had a conversation wondering if this daughter actually had the time and the ability to take care of all the necessities. And my client eventually made the decision to hire Royal Trust as an executor. And there's always an opportunity to hire a trust agent. So when she had passed, Royal Trust took care of everything from start to finish. They made sure that her accounting was done correctly and her income taxes. They made sure that 50 plus years of belongings were cleaned out of her home. They found a realtor, they staged the home, they sold the furniture, and they finally distributed the assets to the beneficiaries, which took the responsibility away from the daughter. And one other piece of this puzzle too that I wanted to mention was that my client was actually a librarian and her husband a professor. And one of the things that meant a lot to them was charitable giving, and having that opportunity to talk with her and ensure that her will was set up appropriately. She was able to put a charitable donation through her will. And she did speak with her children about the fact that this was important. All of her children also went to the universities within the city as well. And it made them feel good to know that mom and dad helped out the universities as part of their legacy. And the children were more than happy. It's one of those kind of happy ending stories that they took the time to make sure that things were done appropriately. Which brings us to our next slide, Megan. Thank you. One of the greatest things with having 4 children who are of university age is the fact that we live in a wonderful city that has 2 universities and colleges and lots of different choice. I value the opportunity for living here. And that's one of the things that I normally talk with my clients about is when you're thinking about your charitable donation, what kinds of areas do you value? And how can you leave that in a legacy in your will? There's many, many different opportunities to donate. Is it through your time? Is it for your financial support? Is it by giving now? Is it by giving in the long term? But there are many different types of products that you can leave as your charitable donation, such as through your stocks. You can have a direct beneficiary through your RSPs, RIFs, TFSAs, or life insurance policies. And I know that Karen will get into the details of the taxation on these, but know that these are opportunities that you have for charitable giving. And thank you, Megan.
Thank you, Elizabeth. That's great to hear so many options and considerations when working out the details of a will. So our final panelist of the night is Karen Wilkinson. Karen, what do you have to share with us tonight?
Thanks, Megan. So as both Keith and Elizabeth have alluded to or mentioned, clearly when we're talking about estate planning and making gifts, as part of that estate plan, there are always tax consequences. As Elizabeth mentioned, if you're looking at your total financial plan, people are going to make sure, generally, people are going to make sure that they have provided for their family first. But many clients will then look at that, and if they've been successful and been able to, accumulate some wealth, they may look at that and say, I've provided enough for my children, and I have some extra, and what do I want to do with that? And that then comes into the question around the charitable giving as part of your will, and making sure that you do it in a way that gets you the right tax outcomes. So there are a number of very specific rules that you must follow in order for your estate to benefit from a gift that you would otherwise be making as part of your will. And those rules changed back in 2016, and tying into Keith's comment about having up-to-date wills, 2016 was a fair bit of time ago, but based on the statistics that he talked about, there's probably a lot of people that where wills are out of date, and their wills may not contemplate the current tax rules. They may be thinking that they're going to have a specific tax outcome as a result of what their wills say, but with the rule changes, that might not, in fact, be the outcome. Because of that, it's really important to make sure that you have someone who reviews your wills, whether that is the lawyer who's helping you with it, whether that's your accounting help, accounting advisor, tax advisor, to look at it and just make sure that the wording that is in your will contemplates the current rules. And there are a number of different ways to make gifts. That you may in your will, specify a specific amount to go to a charity, or maybe you're in a situation like I am, where you would have a residual portion of your estate going to a number of charities. And particularly if you are giving a residual piece of your estate to a charity, that again requires you to really contemplate what the wording is to make sure you get the tax outcome that you were expecting. Obviously, the amount of tax benefit of making a gift depends on where you live. If you're in Ontario, the benefit generally is going to be at the highest rate, which is the 53.5% rate based on the current rules that Keith mentioned earlier. But the benefits do change based on what province you're in, because obviously our tax rates are different between provinces. If you happen to be out of Canada, then you're into a whole different set of rules and a whole different set of requirements from a tax legislation perspective. One of the changes that did happen in 2016 relates to the timing of when you can get the benefit on a tax return from the gift. And now it takes time before you can actually get that tax benefit. And that benefit's not going to happen now until the executors actually are able to administer the estate and actually make the gift to the charity. And again, depending on the complexity of the estate, depending on the circumstances, depending on who your executors are, that can take time. And therefore, there may be a cash flow issue between when the tax is due on your, what we refer to as your terminal tax return, which is your final personal tax return that has to be filed when someone passes away. So you may have some tax that's owing on that return, and you'll have to wait for that benefit until the donation can actually be cash funded by the executors after you pass away. Next slide, Megan. So in terms of how much you can benefit, the rules are a little bit different when the donation is being made as part of a will. Generally, if you're making donations during your lifetime, the donation credit is limited to effectively offsetting 75% of your taxes. The limitation is based on 75% of your taxable income. In the year of death, they actually increase that to 100%, so that from a federal tax perspective, if there is a significant donation, you could be in a situation where you get 100% offset against any federal taxes that are owing. Again, something that just should be mapped out so that you can contemplate it. Certainly in Ontario, currently, the way the Ontario donation credit works is that even though we can eliminate 100% of the federal tax, that may not happen provincially. And in fact, in Ontario right now, the way the rules work, if the donations are significant, you can eliminate 100% of the federal tax, but not all of the provincial tax. So again, it's just a matter of understanding what those rules are and understanding what that means to your estate. As Elizabeth mentioned, there are a number of different ways that you can make a gift as part of your will. You could have a direct beneficiary listed on your RSP or RIFs or life insurance, so that when you pass away, once the administration happens, then the funds go directly from your RSP to the charity that has been named, or whoever that beneficiary is. Alternatively, maybe there isn't a specific direct beneficiary, but those assets get accumulated into the estate, and then the estate makes the donation directly from the estate to the charity of your choice. There can also be, as was mentioned, a bequest of an investment portfolio from the estate to a charity. And again, that generally happens by the investment portfolio coming into the estate and then ultimately being gifted to the charity. And there are some very specific rules that relate to a gift of an investment portfolio around how that taxation works. The most often what I see with wills is actually just cash bequests from the estate, so that the executors accumulate all the assets, and then the will say, give X amount of dollars to a charity, or take a percentage of the residual and give that to the charity. But what I see most often is that just being done through a cash bequest. And there may be other assets that you have, that you own, that you would consider from a gifting perspective. Although different charities have different views on accepting some of these gifts, because they can be a challenge. But maybe you have real estate that you are considering gifting, versus having it sold and then gifting cash, and any other assets that might exist. And last but not least, and we're definitely not going to go into it today, just based on the amount of time, but if you happen to be someone who has their own business and you own shares of a company, there are a number of considerations in terms of potentially gifting shares of that company as part of your will to a charity. Lots of ways you can do that, but also a lot of complications in terms of making sure that your estate actually benefits from that gift. So again, incredibly careful planning is required if you are considering gifting either shares of a company, of a private company, or potentially taking assets out of that private company in order to fund a charitable donation in your will. And with that, I will pass it back to Megan.
Thanks so much, Karen. Some really useful information there from you about taxes, some good things to consider. So without further ado, we are going to move on to our Q&A portion with our panelists. I see that we already have some great questions coming into the Q&A. Just a reminder, if you do have a question, we would love to read it aloud and have someone answer it tonight in the webinar. To make sure that that your question comes through, please use the Q&A option in your bar at the bottom of the screen. So it's the Q&A option, not the chat option. That will help us to make sure that we see your questions. We're going to answer as many questions as possible in this section of the webinar. But if you have a question that comes up after, or if you have a burning question that we don't get to tonight, please feel free to email the address on the screen. That's plannedgiving@uwaterloo.ca. We'll be happy to reply to you. All right, so I am going to bring us all up on the screen together, and we will get into the Q&A. So our first question is for Keith. Keith, can you create a legal will by hand drafting it and signing it with a witness, or do you need to get a lawyer to make it legal? Oh, you're on mute, Keith.
You certainly can. In fact, the laws of Ontario were changed a couple of years ago, and so we're now a substantive jurisdiction. So it might be that you already have and you don't know it, because it used to be that will had to meet certain formalities. It had to be signed, it had to be witnessed, it had to be this, it had to be that. 2 years ago, Ontario changed the rules, so we don't have that anymore. And so now people are finding documents they might not even think were a will, actually are a will. There have been cases where a suicide note has been deemed to be a will, where instructions to a financial advisor has been deemed to be a will, because we no longer need those formalities. But more likely what he's talking about, the questioner is asking about, is holographed wills. A holographed will is a will that's completely in your handwriting and signed by you and dated. It doesn't even need to be witnessed. And that is a legal will in Ontario. My caveat would be, not necessarily is it the right thing to do, because lawyers and financial advisors and tax advisors are all there to make sure your estate is handed down in a proper fashion. And I think the problem with a holographed will is you don't know all the rules that are associated with tax, etc., that make it a better will. One of the cases you're going to learn if you go to law school was about a gentleman who was in Saskatchewan. He was plowing his field and his tractor flipped over and pinned him. And while he was there, he realized no one was coming to save him and he was going to die. So he took his pocket knife and he carved into the side of the tractor, "All for Mother." And that was considered a will. In fact, if you go to the courthouse in Regina, the tractor and the penknife are there in the lobby. So even very informal things can be a will as long as they're signed. The difficulty with that, and I guess the sort of lesson is, he didn't have a mother. He had a wife who he called mother, and there was a bit of a lawsuit over that issue. But you can do it, but you better be sure you understand all the rules. So a long-winded answer for very little. Sorry about that.
That's okay. That was a great example to give, and I am learning something new here. I didn't expect that answer from you. Thanks, Keith. Okay, so our next question is from Elizabeth. So Elizabeth, let's say I'm totally new to this. I do not have anything in place at this point. What are the steps for me to start my estate planning process?
I always think that starting with your financial plan is the most important part. Sitting with someone who's going to ask you the right questions. I have been through so many different financial plans with so many different clients, and it is never the same plan that we give to our clients. It's never the same way twice. My recommendations are always different. Families look different nowadays. Blended families. Sometimes, mom and dad are still around, so you've got multi generations, generations of children, and it's just important to kind of start with sitting down with someone who is going to take the time to understand your needs first and work through what your goals are.
That's great, and good to hear that there is no one size fits all, and the point is to make sure that your specific wishes are put into place. Great, so thanks, Elizabeth. We'll now move on to a question for Karen. Karen, what is the most tax efficient way to transfer funds to a spouse and then to a charity or another recipient?
Yeah, so if your will, I call them standard him to her wills, and I know that's probably not the right way to describe it today. But if your will says, when you pass away, that everything goes to your spouse, there are specific rules in the Income Tax Act that allow that to happen with no immediate tax. So your RSPs, your investment portfolio, any of those assets just become property of your spouse. Or I think Keith mentioned maybe a spouse trust. And that question, direct to your spouse or to a spouse trust, has all sorts of ancillary questions related to that. But you would go to the spouse first, and then it would be up to your spouse to decide what they're going to do in terms of charitable donations. If you give the assets directly to your spouse, then their will decide where those assets go in terms of what charities they go to, what family members they go to. If you don't want to leave that decision to your spouse, then what you would typically see, one of two things. You would have a spouse trust, where the trust would say, when my spouse passes away, then give whatever's left to these people, whether that's children, whether that's grandchildren, whether that's charities. Or what you might do is not give the money to the spouse right up front and actually make the donation directly when you pass away. And what's the most tax effective? Again, as we're going to say a lot, it depends on your circumstances, in terms of just matching up when you're going to pay tax and when you're going to get the tax benefit of the donation, because that's ultimately what you need to make sure, is that they both happen at the same time in order to get the benefit.
That's great. Thanks, Karen. Lots of options there to consider. All right, so we'll flip back to Keith. Keith, what is your professional opinion on the online portal called Willful? What are the pros and cons of doing your will online with a platform like this?
I think of the various platforms online, Willful is one of the better ones. It got input from Hull and Hull, which is a very prestigious law firm doing nothing but estate work in Toronto, when they came up with the thing. Having said that, nothing beats actual advice and going to a lawyer, going to a financial advisor, going to a tax specialist. Nothing beats that. I was curious about Willful, so I actually drafted a will through Willful for myself. And you fill in a whole bunch of things, then it pops out this will. And I found it was good for a basic will. I worried about things like if you have a Henson trust in your will, or if you decide to have a spousal trust for your will, there's a lot of individual conversations that have to go into that, because one size doesn't fit all. And it's very hard to simply go through a form and say, there, I'm done. So I think it's one of the better ones. I think it was very wise of them to go to Hull and Hull and get advice, because that's a great law firm. But I think if you have any complexity in your family whatsoever, and I don't know any of us who don't have some complexity in their family or complexity in your assets, nothing beats personalized advice.
Yeah, that's great to know. Thanks. All right, a follow-up question for you on that, Keith. Can you provide any resources that would help someone learn about a Henson Trust, which you mentioned earlier?
And I imagine Karen could tell us some great ones too. First of all, whoever asked that question, I'm very sorry that you have to worry about this, because that means you're involved with ODSP, and that is just a horrid, horrid thing for anyone to go through. ODSP has, well, that wasn't really the question, so we'll just go through this. I assume this person wants to know not just about Henson Trust, but about Qualified Disability Trust, because the Qualified Disability Trust is so tremendously important now if you're talking about disabled individuals. I've written a few articles on it, which I could probably get to you, Megan, and then you could forward them on if you wanted to. The Law Society of Upper Canada did a seminar. Sorry, the Law Society of Ontario, I forgot the world modernized and I didn't. They did a seminar about a year ago on disability planning, and they had some phenomenal stuff on Henson Trust, which would be really useful for that person. And again, Megan, if you can follow up with that person afterward, I'd be more than thrilled to get that information for them.
And I would just add to that although you always have to be a little bit careful about going to the government site, I do find that the Ontario government site, related to at least some of the basics in terms of getting started, actually has some reasonable introductory material to start and at least get you thinking about what you might need to worry about.
That's great. Thank you, both Keith and Karen. At least somewhere to start for a very complex thing to navigate. All right, Elizabeth, we're going to move on to a question for you. What software can you use to help you in your role as an executor in Ontario?
I would have to say that I haven't had any of my executors ask me about software in the past before. I know that a lot of the funeral homes will provide a guidance package as an executor. So that's usually where my clients have started. But I can take that question offline and find out if there is any opportunities. But I did want to mention at this point as well that if an estate is a task that is much more daunting than the executor who is named is able to take on, they can hire a corporate executor to work with them as well. So if it comes down to that kind of a situation where they found that it's too much, they can have that opportunity. And there is an executor fee that can be charged by the executor. And Keith, you might want to chime in on this one, because at last note, I understand that that fee is to be 5% maximum. Is that correct?
There was a series of cases that went through the courts in the 1990s and the early 2000s. And those cases said that 5% was about what an executor was entitled to.
Okay.
That is then, if it goes to court, they consider 5 different factors. Don't ask me what all of them are. I know that one of them is the complexity of the work done, the size of the estate, then some other ones. The work completed, I think the time. And from there, the courts can actually go up or down. So there are situations where you'll ask for that 5% and the courts will say, no, I'm sorry, we're going to give you a lesser amount. And there are cases where you can ask for a higher amount because the 5 factors show you're entitled to more. But overall, the basic rule is 5% is what an executor is entitled to.
Yes, yes. But definitely an opportunity for someone who is an executor to make the decision. If it starts to become something beyond the complexity that they're able to handle, they can choose to hire a lawyer or corporate executor.
And just on the software, I'm not aware of any software per se. I think a lot of the law firms, at least for Ontario, they do have some software that they use in terms of the reporting that has to go back through the courts or that potentially has to go out to beneficiaries. But to my knowledge, the sort of the clients wouldn't have access to that. One I'm working on right now, we're basically using an Excel file to track all the information and then sending it off to the lawyers for them to then input into the software that the lawyers use for reporting purposes. So I'm not aware that there's software out there, but there might be, but I'm just not aware of any.
Yeah, there are a few options, Karen. You know Rudy Mizada from advisor.ca. He wrote an article last March, and he interviewed 2 companies that do offer that software. Clear Estate and Estate Planner that had an after-death package. I don't know anything about them, don't know if they're good or not, but if you want to go read advisor.ca last March, you'll see an article by Rudy there that talked about those and talked about their advantages and disadvantages.
Oh, that's great. Okay, lots of information there for executors. Thank you, everyone. Okay, so this next question is directed towards Karen. Karen, how does an inheritance affect one's ability to collect ODSP? So beyond a Henson Trust, what other trusts or resources should someone be aware of for providing for a disabled dependent?
Yeah, so complex question for sure, and some of this is tax and some of this is legal. So I'll start, and then I'm sure Keith will jump in. The challenge with ODSP is that it's a means tested income. So if you leave a bunch of assets that are going to generate income to a disabled individual, then they're just not going to be entitled to ODSP going forward, because their income's going to be, their other income from other sources is going to be too high, and therefore ODSP just does not become an issue because they're not entitled to it anymore. Which is why you typically see the planning with a Henson Trust, and then from a tax perspective, qualifying disability trusts, to try and be in a situation where you're providing the person with incremental assets and income, but doing that in a way so that they're also still entitled to the ODSP benefits. And again, lots of issues, lots of complications to get to the right answer on that one, that involve, in a lot of ways, primarily legal issues, which then some tax things get layered on top of that. So Keith, I don't know if you want to add anything on that.
No, I think you gave a really good answer. I think that it's a terrible process because the income that a person's allowed to have and be on ODSP is very small. So even smallish gifts left to someone can boot them off of ODSP. And I know from experience, it's not just the income, it's the social worker and the drug card that are so tremendously important to people on disability that can be scraped away from them. As Karen was saying, the Henson Trust and the Qualified Disability Trust go hand in hand. Sometimes they're the same trust. And it's really important to get advice on both. But I think you knocked it out of the park with your answer. I don't have much to add at all.
Great. Yeah, thanks. Just lots of information to sift through there with the Henson Trust. Keith, we're going to stick with you. We have a question asking, how can I ensure my wishes are respected and followed by my executor, trustee, and beneficiaries?
Well, that's a very interesting question. I mean, the legal answer is that your executor is legally required to it's a fiduciary position, and they have a fiduciary duty to oversee your wishes and make sure those wishes are true, come true, and they follow your will. If the person has any doubts about that, I would consider hiring a professional executor, because the one thing about a professional executor is, that will be administered to the letter of the law, and what wishes you have in there will be respected, because that's their job. Every executor, that's their job, but a professional executor, they have to do that. So I think that's one place of comfort. They can get some comfort for that thing. Other than that, I guess it's trust your family.
Right. Good to know that there's that professional option out there. All right. So Elizabeth, we have a question that has been a very talked about topic tonight. What do you consider an out-of-date will?
And I'm sure Keith would chime into this, but I typically say that my clients should be checking out their will at least every 3 years, but also the same thing with their financial plan. Anytime there is a major life change that happens, marriage, divorce, new kids, new grandkids, finding out that someone has a disability and needs to be taken care of, any major changes in life, you should be contacting your financial planner. You should be updating that will and taking a look to make sure it makes sense. Now, Keith, does that make sense to you every 3 years, or is it?
No, I think every
what do
3
you
years.
recommend?
I think every 3 years is about the right amount. Karen might have different views, because one view is every time the federal budget comes out, you should at least dust it off and see what's happening. But I think every 3 years you're bound to catch the big things. But I really emphasize and agree with you on event oriented. Was there a marriage? Was there a birth? Was there a divorce? Anything like that, I think really behooves you to look at the thing quite quickly.
Yes. I typically meet with my clients on an annual basis, and I do touch base with them, asking them that question. But it's always good to, as you said, just dust it off and take a look.
That's great. Good to have like a straight up number here. That's one that we can say, everyone, 3 years. Okay, great. So our next question is for Karen. Karen, what financial advice would help when someone's assets are quite liquid? For example, mostly money in bank accounts and not necessarily invested.
Yeah, so I'm not exactly sure certainly from a gifting perspective, in a lot of ways, it doesn't matter whether it's an investment portfolio or cash. The tax consequences might be slightly different, but certainly ultimately the tax consequences aren't going to be that dramatically different. I think Elizabeth would say from a financial plan perspective, there's a different conversation about maximizing how you're dealing with your financial assets so that you're maximizing from both an income perspective and an asset growth perspective. And different people are going to have different views depending on how the market's going at any particular time about cash versus not cash. But I'm not the investment advisor. That I will defer that question to Elizabeth, but hopefully that helps.
And most definitely, I know the markets aren't quite as favorable right now, but there are places always to park your money that are much better than cash. And frankly, you don't want to just keep your money sitting in a bank account. That's never the never the best solution for that. Yes.
Yeah, all right. So we're also getting some banking advice here. That's great. Um, Great. Okay, so we're back to Keith now. Keith, you were talking about professional executors earlier. How much would a professional executor charge?
Well, that's tough to say, because one thing with a professional executor is you negotiate the fee prior to entering the will. Every one of the professional executors, whether it be Royal Bank or whether it be the Canada Trust Company or whoever it might be, are going to negotiate that fee agreement. For smaller estates, there's going to be a minimum fee, and then there's going to be a percentage after that. But for very large estates, let's say the person's worth millions and millions and millions, they'll do a personal negotiation on it. The advantage, regardless of what the amount will be, and I suspect for sort of your average estate, it'd be close to 5%, depending on which bank, which financial institution you go to. The advantage is the bank is then stuck with it because it becomes a appendix, if you will, to your will. And so if tomorrow morning the government of Canada says executors are now entitled to 15% instead of the 5%, that's too bad for the bank because they negotiated a fee agreement that's attached to it. So it gives you some certainty of what someone's going to charge as well. If I hire my son will do a good job, I'm sure. He's a good guy, but I don't have the same comfort about what he's going to charge because we didn't enter into that negotiation.
And just adding to that, Keith, I know that when my clients have gone into the Royal Trust office, they're signing that agreement in advance so they can see that fee structure. So the client is very aware what the cost associated with what it will be essentially. So it's nice just to see it in black and white and know what the percentage will be.
Well, that's great. Thank you both. All right, Elizabeth, we're gonna ask you a question next. We'll stick with you. How can newcomers in Canada ensure that their relatives abroad are taken care of by their estate or will? And does the government of Canada honor those wishes?
So absolutely. If you're creating a will and you're having a beneficiary out of the country, that it's no different than having a beneficiary in here. However, there is different taxation laws that come into place. So depending on where the inheritance is going, I know that there will be taxes that will have to be paid. So that is definitely something to take into consideration, is understanding where your beneficiaries are and what type of taxes. Depending on the country, that can be very different. But at the end of the day, you want your beneficiaries to receive some assets. Taxes are just part of what will have to be paid if that's the case. Karen, do you know specifically outside of Canada the different taxes? I know the US definitely has a set percentage for inheritance.
Well, yeah. So a couple of things. It depends on obviously the country because every country has its own laws. So if you have a foreign beneficiary, again, a reason to have the conversation up front and not only talking to Canadian advisors, you probably want to be talking to US advisors if they're in the US or wherever they are in the world to understand it, to make sure that you're contemplating both sides of the border. If you've got a Canadian who's gifting money into the US, again, I'm not a US tax person, but on the receipt of that gift, as long as the person, if the person who is here is not a US person, then the gift to a US person is actually relatively straightforward. If you're living in Canada, but you happen to be a US person, so a US citizen or a US green card holder, your estate just got exponentially more complicated because now you have to deal with both the Canadian rules and the US rules. And again, we see that all the time. So we have lots of folks in Canada who have a history with the US. Maybe a parent was a citizen and therefore they are by definition a US person. So lots of complications if you've got connections into the US.
Yes, most definitely. So it is best just to talk to the advisor of the person that you're thinking of leaving the inheritance to, or at least finding out more about that country's tax rules. Thank you.
For sure.
Yeah, great. Great things to consider there. All right, so Karen, we have a question for you. Can you explain the tax implications of receiving a property from a deceased family member? The property would not be used as a primary residence and would be sold. Would capital gains apply?
Yeah, so there's sort of two steps. The first is what happens when the individual passes away. And I think Keith alluded to this when he was talking about, from a Canadian tax perspective, what happens is that property, it's as if it was sold for fair market value. So let's say I'll just use an example. So my mother owns a piece of property. She passes away, leaves it to me. When she passes away, she's considered to sell that for fair market value. Let's just assume it's worth $500,000. Whatever the capital gain is when she passes away, her estate effectively pays that tax. That property then comes to me, and I now own that property. From a tax perspective, my cost is, in my example, that $500,000. If it goes up to $600,000 before I sell it, then I'm going to pay capital gains tax on that $100,000 increase in value. So there's kind of two layers. There's the gain when the person passes away, and then there's the gain subsequent, and they get taxed. Ultimately, the tax rules are the same. It's just a question of what tax return does it get reported on.
Yeah, okay. So thanks for breaking down both those steps. We have a follow-up to that question. How can you avoid having your estate having to pay the probate tax or the estate administration tax?
Yeah, so that, again, that's probably a whole different conversation. But my comment to a lot of clients, first and foremost, is really think about whether avoiding probate is worth it, because I've seen way too many circumstances where people jump through huge amounts of hoops, and ultimately, therefore, their assets don't actually go where they really wanted them to go because they tried to avoid probate, which, yes, if you don't have to pay it, that's great, but it is only 1.5%. So, circumstances where, we had, again, I'll just use a mother, had an investment portfolio, wanted to avoid probate, so put one of their children on as a joint owner on that account. Yes, it avoided probate, but now that asset went just to the joint owner because it didn't go through their will. And maybe their will said, take that asset and divide it equally among their 3 children. Well, now their wishes under their will aren't going to be accomplished because they did something else to avoid probate. So you just have to be careful. That the easiest way to avoid probate is joint ownership. But again, just be careful about whether or not that actually makes sense. If you're in a situation where you're more complex, certainly in Ontario, if you're a small business owner, most small business owners have what we refer to as dual wills, sort of one will that's subject to probate and a second will that's not subject to probate. So again, probate planning, it has its own conversations for sure. But as I said, I just be careful about doing too much to avoid something that in the end isn't a huge number necessarily.
Can I just add one thought to that?
Go
I thought
for it,
what
Keith.
Karen said was all wonderful. I want my executor to get probate. I don't want it to be avoided. My executor is someone I love very much. It's my son. And so I want to protect him. And probate is not just a tax. It serves a purpose. And I think a lot of people miss that. It's 1.5% of your estate, which is not huge, especially when you think of, registered accounts with beneficiaries named and all that sort of thing. But there's 2 issues that I worry about with avoiding probate. One of them is, if anyone sues my estate, let's say my son starts administering my estate and doesn't get probate, because probate's not mandatory. If you can convince every financial institution, everyone else out there in the world to avoid probate, good for you. You don't have to get probate. But if Jack does that, and then later there's a dispute about my will, someone says I had undue influence or didn't have capacity or just takes a run at my will for whatever reason, Jack has become what's called an executor de son tort. And an executor de son tort means that he has to complete the administration because he's a fiduciary and he took it on, but he can never be paid and he can't be reimbursed for any expenses he incurs. So I want him to get probate because if he gets probate, that doesn't happen. The other thing is, there was a case so many years ago, I can't remember, called Libel and Libel. And Libel and Libel looked at our Limitations Act in Ontario. And it says that, I think it's, you might have to help me here, Karen, I think it's 6 years after decease, you lose the right to sue. That's not right. 6 years after you knew or ought to have known you had a claim against an estate, you can't sue. Well, when did I know or ought to have known? And the answer was, according to that case, if you applied for probate, the entire world is deemed to know what's in a will. So it starts from that date. But if you don't get probate, those limitation periods might not start. And I want Jack to go to bed someday knowing no one can make a run at this estate, it's all over. So I don't find probate as an evil. I think it's something that benefits someone I love very much. It's the same reason I buy life insurance, to benefit someone I love very much. Anyway, that's my 2 cents also on it.
Yeah, that's great. So probate, not a bad thing. Thanks. Great. Okay. So this next question, I'll offer it up to Keith, or maybe Karen, you might want to jump in here too. Is there anything I specifically need to know about electing to leave our total estate to one or more of the First Nations on whose land we live on and work? Any thoughts on that?
Yeah, no, I don't have any great thoughts. So the Indigenous taxation is a complete, like, that's a very narrow specialty that I have never had to answer that question. So I actually don't know the answer as to whether there's anything unique you have to do or something to think about. So I'd have to say you need to talk to someone who deals with the various Indigenous groups, and also someone who deals with Indigenous taxation, which is its own sort of specialty area.
Yeah, I do the same thing. I think you have to deal with a specialist in that area. And I'd also talk to the Aboriginal community you're thinking of leaving the gift to. Some of them may prefer to have it in what's called an Aboriginal trust, which has some advantages to the Aboriginal community, or might have specific plans that they would want in place. So I'd talk to them, and I'd also talk to the experts Karen mentioned.
Mm-hmm. Yeah, that's great to know. We are learning that there are many specialties that and many specialists that you can go and talk to in these areas. So that's great. Okay, so Elizabeth, we'll move on to a question for you. What are your thoughts about a living will? Do living wills have the power to end a person's life, like assisted suicide, if their brain is truly damaged, for example?
I'm going to pass this right over to Keith because I have never had
Yeah.
to deal with a living will before. I hope that's okay, Keith, to put you on the spot for that one. But definitely.
And Karen, jump in when you can. I don't believe that doctor-assisted suicide can be, I don't believe at the moment, I know there were some amendments proposed, but I don't think those amendments have been completed. I don't think anyone but the individual can make that decision. I think they have to be made contemporaneously. Karen, okay, thank you. Contemporaneously with the event. So I don't think they're going to help in a living will. Instructions about to take you off of life support, etc., are completely different. And I think that those are best put in a living will or a power of attorney. And I think also it's really, really, really important for your clients to talk to their family members about whether they actually will do the instructions if they're told to. There was a case called Friedberg maybe 5 years ago. And what happened in the Friedberg case was a woman named Mrs. Friedberg. She was 86 years old. She used to go down to Florida every year. And while she was down in Florida, she had a terrible stroke. She was eventually airlifted back to Toronto to the Baycrest Center. And her doctor who looked after her, Dr. Korn, got all her documentation, her living will and all that sort of stuff. And he called her three daughters in and said, great news, you guys have been named your mother's trustee in these documents. You're going to be the ones making the decision. Oh, and by the way, read it. It says right here that she wants no heroic measures to extend her life. In other words, remove her from life support if she has no ability to, if she has no chance of a quality life. And Dr. Korn said, and she has no chance. She will never come out of this coma she's in, and it's best to unplug. And the daughters sat there and said, what are we going to do? We're Orthodox Jews. Our mother was a very, very strict Orthodox Jew. This is one of the biggest sins possible in our religion. We just can't do this. So they refused. Dr. Korn took it to a tribunal to have their opinion overturned. And the tribunal said, called the lawyer who drafted the documents. And the lawyer who drafted the documents gave sort of interesting evidence. She said, I don't remember this woman at all, Mrs. Friedberg. I don't remember, I don't have any notes or records about my conversation with her. And I don't remember talking to her about her religious values because I never talked to anyone about their religious values. I put that clause in every single document I draft about no heroic measures because 99% of us want that. And she said, but I probably read it over with her. The tribunal said, based on that, we believe Mrs. Friedberg knew exactly what was in that document, and we're overturning the daughter's opinion. Daughter's then the daughter's instructions. The daughters then appealed to the court and had that overturned. So I think that the message I'm trying to get across, rather badly, but I think the message I'm trying to get across is communicate, communicate, communicate. The University of Toronto's bioethics department did a great article about, maybe 12 years ago. I have a copy of it around if you can't find it. And it said, here's the things you should talk to your family about when drafting a living will. And every one of them is so important. Should I be provided morphine if I'm in a home? What if I have a major stroke? Do I get moved to a nursing home, or do I spend every nickel I have so I can stay here? So it goes through all those things that you should communicate. So I guess the easy answer is, other than doctor-assisted suicide, that document will provide for your wishes. But please make sure your family knows what your wishes are and that you fully know what your wishes are by going through something like the bioethics department's webpage.
Yeah, that's great. A real big takeaway of tonight, Keith, to communicate with your family, with the people who will be executing everything in your will. Okay, so let's see. Our next question is for Karen. Karen, can you comment on the GRE method of gifting over 3 years from death?
Yeah, so the GRE, so tax people are great at doing short forms. So it's a graduated rate estate. And that's one of the changes that happened back in 2016 when they changed the rules significantly. So there's a bunch of things. One is you have to qualify, your will has to create this thing considered a graduated rate estate. And it has to be a qualifying GRE. And there's things that have to be done when your tax returns are filed to have one of these things. And this is one where after the rule changes, your will may not have the right wording in it to actually have a graduated rate estate. But at the end of the day, if you have a graduated rate estate, then you have the ability for donations to be carried back to that final personal tax return. If you don't have a graduated rate estate and you leave donations in your will, then you actually can't get any tax relief on your final personal tax return because there's a restriction on your ability to claim those donations. So again, just getting the right wording and making sure that you contemplate them is important.
And another nod to making sure it's up to date as well. So that's great. All right, Keith, we're going to go back to you. Can wills stipulate requests pertaining to burials and funerals? Is the guardianship of children part of a will as well?
Your will can state anything you want. So if you want to put in your will, and quite often you see it in the will, information about burials and things like that, that's a perfectly fine place to put it, subject to this. Sometimes people read the will after the burial. And so I think, again, and I realize I'm sounding like a broken record, it's best to have those instructions with family prior to that so they know what you want. I think that's just wiser. Certainly, if you have minor children, you should have a guardianship clause in your will talking about where those children will go if you pass away. To the extent you can possibly name someone, that's a great thing. You can't, obviously, if you have child has two parents, those parents are separated, a guardianship clause that excludes the other parent from consideration is a little questionable, but certainly a will should have a guardianship clause in it. Now, it's important to remember, guardianship clause in the province of Ontario are only good for 90 days. All it's doing is saying, this is the person I want my children to go to immediately. Within those 90-day period, anybody, usually it's simply the people named in the will, but anybody could make application to the court to say, I want to be named the permanent guardian of the child. But it's an important thing because it tells what your wishes are and it gives the children somewhere to go for those 90-day period.
Great info. Thank you, Keith. Okay, so Elizabeth, a question for you. How can I protect my assets from creditors and lawsuits?
Absolutely. It's a difficult thing to look at, but when you're I know we're talking more about estate planning and will planning, but when you're looking at your individual assets that you've got, looking at the joint ownership and the types of products that you're holding them in. A lot of times you can hold your RSPs for yourselves, and that will prevent it from coming into the realm. So it's just the different types of products that you have, and RSPs would be one of them. But ultimately, you need to pay your debt. So it's hard to hide from creditors, but yeah, the objective is get your debts paid. You could be gifting money to your children, looking at, I guess, in the situation, if you're a professional and you would have a lawsuit against you for, improper advice that you may have given. Doctors always have some kind of an insurance clause put in place for themselves. So taking a look at the different kinds of insurance clauses to make sure you're protected in that way. But if you're just talking about debt protection, it's hard to get away from debt protection in that case. So hopefully I'm answering that question to the breadth of what you're expecting, but take the opportunity, if you're professional, making sure you've got errors and omissions clauses. I'm not sure what it's called for doctors again, but yeah. And Keith, you probably kind of have some kind of insurance as well for yourself in the case someone would come back to you. I know I was just talking with my lawyer and she said the largest cases against lawyers right now, it used to be real estate, but it's now wills and estates that is happening, that they're saying that lawyers may not be completing things, and it's the largest amount of court cases that are happening at this point. So yes.
Wow, yeah, that's great. Thanks. Thanks so much, Elizabeth. Okay, so we're moving on to a question for Karen. Karen, we're hoping that we can get an example with real numbers here. So let's say, for example, I have $1 million. How much does the federal and provincial government take? Let's just continue with Ontario with this one. How much would I have to gift to avoid the maximum taxes? And is there any specific wording to avoid when we're gifting in order to avoid unnecessary taxes?
Yeah, so again, I'll try and do with real numbers, but if you've got $1 million, how much tax you might save actually depends on what that asset is. If it's an RSP that's worth $1 million and you pass away, you've got $1 million of income that's subject to tax. If you take that $1 million and give it to a charity, then effectively you're completely offsetting the tax. If you got $1 million, you would pay tax on that $1 million of RSP income at 53.5, and you would get a tax credit for your $1 million donation at 53.5, so they would net together. If that was a investment portfolio that was worth $1 million but only had a $250,000 capital gain as part of that, and you give the whole $1 million away, well, now your gift is significantly more than the tax that you're going to pay on that investment portfolio. So I know it's numbers, but again, it's so dependent on what that underlying asset is and the tax treatment of that asset. But ultimately, in Ontario, if you're going to gift $1 million, the tax savings is going to be basically 53.5%.
That's great. Thanks for walking us through that. I think one of my number one lessons here is that I need to talk to someone about my specific circumstance when creating a will. So that's great. All right, Keith. Does an insurance policy payout go through a probate, Keith?
It depends on who the beneficiary is. If the beneficiary is the estate, so you've not named a beneficiary or you put down as your estate, then it certainly would pass through the estate and attract probate. If you've named anyone else, your son, your daughter, your wife, whoever it is, then it passes outside the estate and doesn't attract probate.
Yeah, that's great. Thank you. Okay, Elizabeth, I have a situation to lay out here for you with this next question. So let's say I made a basic will in the UK when I was 20 years old. How would I go about updating my will to include my soon-to-be common law spouse now here in Ontario? Is there a process for transferring and updating the will to Canada and also ensuring that we would both get the maximum benefits and tax breaks?
So definitely the will that you have there could be replaced with a new will here. I believe it's a part of the clause from the lawyer that they would put something in it saying that they would renounce the old will. But it's always the most updated one is the one that would be actioned. And again, it's about sitting down with your common law partner, understanding what both of your goals are, and making sure that your financial plan is aligned and making sure that your will is aligned with your goals. Just if you're a common law partner, there's a lot of assets that may be considered joint. So it's really about understanding what your objectives are and recreating that will here. And it would renounce the old one. So nothing special. You don't have to go back to the UK and tear it up. But yes, it's just have to start anew.
So Megan, just a related thing which we do see regularly is someone who's in Canada has a Canadian will, but actually owns property someplace else. Again, particularly here, maybe has a vacation property somewhere in the US. Again, that's something where most of the lawyers I deal with that would say, you need to have your Canadian will that deals with all of your assets, but you probably also need to have a will drafted by somebody in the US that complies with US rules in order to make sure that that US property gets dealt with the way you want it to. So there's kind of both sides of that. If you've changed around and moved around having an up-to-date Canadian will or having a valid Canadian will, but you may also need wills for other jurisdictions if you own assets outside of Canada.
Yeah, I was going to jump in and Karen took the words out of my mouth. That's tremendously important. There are tax differentiation between the different states as well. Hawaii has some very unique systems for property ownership and division. The other thing, though, that I'm just going to throw in when we're talking about international is also make sure if you have assets in Florida or Arizona, wherever it might be, that you have powers of attorney down there as well. Powers of attorney are provincial only. So you might have a power of attorney that meets the requirement in Ontario, but it doesn't meet the requirements in Florida. Florida's power of attorneys have to have a clause that says this is a continuing power of attorney under section 218.1, I believe it is, of the Florida Code. There's not a power of attorney in Ontario that's going to have that. So make sure you also have powers of attorney as well as wills in place in different jurisdictions if you have assets there.
That's great. All great thoughts. Great to have all three of you chime into that question. Okay, so Karen, the next one is for you. can money or property be gifted to a child versus a charity?
Absolutely. Your will basically says take all of my assets, bring them all together, and give them to whatever your will says. That could be your spouse, it could be your children, could be your grandchildren, could be a charity, but they're all gifts through your will to whoever you name as the beneficiary under your will.
And just one caveat there too, is that if a child is under the age of majority, if depending on what the asset is, I have many clients who want to leave, their RSPs or their assets to their children, and I always caution them, as they're younger, you might not want to do that, or if you are doing that, then make sure you have I want to call it a guardianship clause in your will to ensure that the asset can transfer to the children, but you're going to have a trustee or a guardian who's looking after those funds until they reach the age of majority. But also sometimes you don't want your 18-year-old to have the funds in their hands because they may be buying fancy sports cars and other things that you might not approve of. So yeah, just taking a minute to think about what happens if my 18-year-old receives those assets when they come to age of majority.
Yes, a fair question to consider. Great, thank you, Karen and Elizabeth. Okay, so Keith, are wills filed somewhere, for example, with the government? My will is 30 plus years old and I cannot find it. I don't remember who my lawyer was at the time, so I don't know how to access it. What is your advice here, Keith?
Well, the short answer is maybe. There is a will bank in Ontario. Very few wills are actually in it. It's mandatory, though, that if you are a retiring lawyer, the wills are transferred to it. So if this person can't find their will, they can always try and contact that. I would suggest, and I know this is a silly way out, that they enter a new will that revokes the old will, get rid of it. If their will's 30 years old, it's probably out of date anyway, and enter a new one. That's much faster. And very, very few wills are actually in the database.
That's great to know. Thanks, Keith. All right, so we're going to have one more question for Elizabeth and Karen, and then we'll wrap things up. So Elizabeth, first to you. If I have a joint account with someone other than my spouse, will the funds automatically pass to the other person on my death?
If the account is made joint, short answer is yes.
Great.
Mm-hmm.
Simple answer. Wow, that's awesome. Okay, so then we have one more question for Karen. Karen, which assets should I use to make a charitable gift? Cash or appreciated securities like stocks, bonds, mutual funds?
Yeah, so during your lifetime, the standard answer would be use the appreciated securities because you get a better tax treatment. And that same tax treatment exists if you're doing the gift through your will. But there's some additional complications because it takes time for your executors to administer your estate and ultimately make that donation. And you only get that preferential tax treatment for a gift of appreciated security if you had 100 shares of RBC when the person passed away, and those 100 shares of RBC are still there when you make the gift and you gift those shares, then you can get the tax treatment for the appreciated security. Otherwise, if you've sold the RBC security shares and you've bought TD shares, well, now you don't get the preferential treatment anyway. So it's just, again, it's just got some added complications if you're doing appreciated stock for a gift in a will, which is why I think, again, I said earlier, most of the ones I see tend to be cash because cash is just easier ultimately.
Yeah, that's great. Thanks, Karen. And thank you to you, Keith and Elizabeth, as well. It's been great to have all three of you join for the webinar. We appreciated your presentations, and we appreciated you getting through as many questions as you did. I know that we still had a number of questions that we didn't get to. I wanted to remind you all that if you have a burning question that we didn't get to and you would like to reach out about it, you can email plannedgiving@uwaterloo.ca. We'd be happy to reply to you. And finally, if you want to revisit any of the information that you've learned tonight, there will be a recording posted of this webinar, and we'll also be sending that out in an email to all of the attendees as well. Thank you so much for joining us tonight, everyone. It's been great to spend this time with you.